Welcome to the Deep Dive, where we take stacks of information articles, research our own notes, and really try to extract the most important nuggets of knowledge or insight for you. Today, we're doing a special deep dive into a truly, well, thought-provoking legal case. It went all the way to South Africa's Constitutional Court. Now, this isn't just for law students, though. You'll certainly gain some invaluable legal insights here. This deep dive is really for anyone who's ever signed a contract, bought insurance, or maybe just wondered how our big abstract constitutional rights actually play out in, real everyday life. Imagine this. A car accident happens. You make an insurance claim, and then there's this tiny clause buried somewhere in the fine print that suddenly becomes the biggest hurdle between you and, well, justice. That's pretty much the heart of Barkhuizen v. Napier.
Yeah, and what's truly fascinating here is how this single case, it forces us to confront these really fundamental questions. Questions about fairness in contracts, the power balance between, say, individuals and large companies, and the very essence of what it means to have access to court in a democratic society. It's a compelling story, actually. It really showcases how the law is constantly evolving, and it offers some incredible lessons on, legal issues, arguments, and their real-world impact.
Okay, so let's start at the beginning. Our story begins with Baron Petrus Barkhuizen. He's the applicant in this case. He had a short-term insurance policy for his car, a 1999 BMW 328. The policy was with a syndicate of Lloyd's underwriters, represented by Ronald Stewart Napier. So back in November 1999, his BMW was involved in an accident. Pretty serious, damage beyond economic repair. He did everything right, seems like. Promptly notified his insurer on December 2nd, 1999, and submitted his claim for $181,000.
Right. But here's where the plot thickens, as they say. On January 7th, 2000, so just over a month later, the insurer, Napier, repudiated the claim. Now, for those maybe not familiar with the legal jargon, repudiated just means they rejected it, flat out.
Okay, rejected. And why? What was their reason?
The reason was they alleged the vehicle was used for business purposes, but there was an undertaking in the policy, apparently, that it would only be used for private purposes, so a breach of condition, basically.
Oh, okay, so the claim was rejected just over a month after the accident. That must have been, well, a bitter blow, especially if you're relying on that insurance payout. Right, so fast forward 2 years. 2 years later, January 8th, 2002, Mr. Barkhuizen finally institutes legal action. He sues to claim his $181,000. But the insurer meets his summons with something called a special plea.
Yeah, a special plea. And what that is, essentially, it's a legal argument raised before you even get to the main issues of the trial. It basically says, look, even if everything the claimant says is true, there's a specific legal reason why they can't actually sue us right now.
And what was that specific reason here?
In this case, it was a very specific clause in the policy itself, clause 5.2.5. And it stated, let me get the wording right. If we reject liability for any claim made under this policy, we will be released from liability unless summons is served within 90 days of repudiation.
90 days.
Okay.
So the insurer argued that because Barkhuizen waited 2 years, not the 90 days after they rejected his claim, they were completely off the hook, released from liability.
Exactly. Now, Mr. Barkhuizen admitted he conceded he didn't comply with that 90-day period. He couldn't really argue that point. But his argument was different. He argued the clause itself was contrary to what's called public policy.
The public policy means?
And it goes against the fundamental legal convictions or values of the community. He said it set an unreasonably short time limit, and crucially, that it infringed on his fundamental right to access the court. He specifically pointed to Section 34 of the Constitution.
Right. Section 34, the right to have disputes settled in court. So let's just pause and, put ourselves in Mr. Barkhuizen's shoes for a second. You think you have a valid claim? Maybe you do. The insurer rejects it. And then this clause, maybe you didn't even notice it when you signed up, tucked away in the fine print, suddenly becomes this giant wall blocking your path to court. That's got to be incredibly frustrating. So with that legal battle line drawn, freedom of contract on one side, access to court on the other, Mr. Barkhuizen started his, uphill battle. He took his case first to the Pretoria High Court. But before we get into the court journey, let's just quickly unpack that core tension you mentioned.
Yeah.
This clash between freedom of contract and the constitutional right to access the courts.
Yeah.
Because this isn't just abstract legal theory, right? It's about whether signing a piece of paper can effectively cancel out one of your fundamental constitutional rights.
Precisely. On the one hand, you have this really old established principle, pacta sunt servanda.
The Latin phrase, yeah.
Meaning agreements are binding and must be enforced. It's fundamental to commerce, to certainty. And as the court self-noted, it actually gives effect to constitutional values too, like freedom and dignity, allowing people to, regulate their own affairs through contracts. It gives contracts their teeth.
Okay, so that's one side, the power of the contract. But on the other side, you have Section 34 of the South African Constitution, which clearly states, everyone has the right to have any dispute that can be resolved by the application of law decided in a fair public hearing before a court.
And that right is absolutely foundational. The court emphasized this. It's about ensuring peaceful resolution of disputes. It's a bulwark, really, against people taking the law into their own hands, against vigilantism, chaos. It's vital for a society based on the rule of law.
So the big question for the court then was, when these two powerful principles clash a contract with a tight deadline versus the fundamental right to go to court, which one wins? Or how do you decide? And I'm guessing the answer isn't just like always the Constitution or always the contract. There must be some kind of guidepost.
Exactly right. And that's where this crucial concept of public policy comes into play. Public policy isn't some static, dusty idea. It represents the legal convictions of the community. And crucially, in modern South Africa, the court said it's now deeply rooted in the values of the Constitution itself.
Ah, okay. So values like human dignity, equality, freedom.
Precisely those. So any contract term that fundamentally undermines these values or is inimical to them could be seen as contrary to public policy. And if it is, it's unenforceable, even if you signed it.
Wow. So the Constitution is sort of acting like an invisible layer over every contract, checking if it aligns with our basic societal values. That's a pretty major shift in thinking, isn't it?
It is. It really is.
And then there was this other complex legal thing you mentioned earlier, horizontality. That sounds technical.
It can be, but the basic idea is this. Normally, the Bill of Rights protects you from the government, from the state. That's vertical application.
Yep.
Horizontality asks, how do these rights apply between private individuals or entities, like between you and your insurance company?
Right. Can I directly use, say, my right to dignity to challenge a clause in my cell phone contract? Or does it have to work indirectly, maybe through public policy, like we just discussed?
That was a central debate in this case. Direct versus indirect application. How exactly does the Constitution police private agreements?
Okay. And one last point before we track the case through the courts. Time limit clauses in contracts. They're not automatically bad, are they?
No, not at all. Courts definitely recognize their importance. They prevent stale claims, where evidence gets lost, witnesses forget things, memories fade, litigation needs some finality. So the question isn't if time limits can exist in contracts, but how they can exist fairly. What's a reasonable limit? Under what circumstances?
Okay, so the need for certainty is real. But I guess, going back to Barkhuizen, does a 90-day limit really strike that balance fairly?
Right.
Especially considering how long it can take to even, find a lawyer and get things moving.
And that is precisely the tension the courts were grappling with here. It's where the judges, particularly the dissenting ones, had very different views on what fair meant in practice.
Right. So Barkhuizen brings his claim. Napier, the insurer, points to the 90-day clause. It really does remind me of how quickly we all click I agree on those endless online terms and conditions without reading a word until something goes wrong. So the case first landed in the Pretoria High Court. What happened there?
Well, the High Court focused squarely on the Section 34 argument, the right of access to court. And it found that Clause 5.2.5, the 90-day limit, was inconsistent with that right. So it declared the clause invalid. Done.
Okay, so a win for Barkhuizen initially. But you mentioned earlier they had to link it to a law of general application.
Yeah.
How do they do that for a private contract clause?
Yes, the technical bit. So the Constitution's limitation clause, Section 36, usually applies when a law made by Parliament limits a right. A contract clause isn't a law passed by Parliament. So the High Court needed a peg to hang the constitutional challenge on. They found it in the common law principle of pacta sunt servanda, the principle that enforces contracts. They essentially said, when the common law enforces this specific clause, it acts like a law limiting the Section 34 right, so we can test it against the Constitution. It was quite a clever piece of legal reasoning to allow the direct constitutional scrutiny.
Got it. A way to bridge the gap between private contracts and constitutional rights. And the High Court also relied on a previous case.
Yes, Malome v. Minister of Defense. In that case, the Constitutional Court had struck down a statutory time limit, a 6-month limit, for suing the defense force because it was just too short and too rigid. No flexibility.
Okay, so the High Court saw a parallel. But the journey didn't end there. The insurer appealed.
Indeed. The case went up to the Supreme Court of Appeal, the SCA. And the SCA took a very different view. They accepted the general principle. Yes, contract terms are subject to the Constitution, and yes, public policy gets its content from constitutional values, but they found the actual evidence presented in Barkhuizen's specific case was extremely slim, too thin to decide if constitutional values had actually been violated for him.
What kind of evidence were they looking for?
The SCA said that figuring out if the 90-day period was reasonable would depend on things like the specific insurer's claims procedures, their resources, maybe even the premiums charged. None of that information was on the record.
So they wanted more context about the practicalities of the insurance industry itself.
Exactly. And they also put a lot of emphasis back on dignity and autonomy, specifically the liberty to regulate one's life by freely engaging contractual arrangements. They warned courts to be careful not to just impose their own personal ideas of fairness onto private agreements. Their underlying tone was very much about upholding the contract people sign.
And they distinguished that Maloney case, the one the High Court relied on.
Yes, crucially. They said Maloney dealt with a right to sue the state, which existed before any contract. But Barkhuizen's right to claim the R$181,000 only arose because of the insurance contract itself. Since there was no specific evidence brought forward to show that Barkhuizen hadn't entered the contract freely or that he was in a massively unequal bargaining position.
They basically said the contract stands.
Pretty much. They upheld the insurer's appeal. The clause was deemed valid in his circumstances, so the SCA sided with the contract.
Okay, so High Court says clause is invalid. SCA says clause is valid. The stage was well and truly set for the Constitutional Court to have the final say. This was the big one. And the majority judgment, written by Justice Enkobo, seems to have laid out a clear path forward.
Yes, it really clarified what the court saw as the proper approach when someone challenges a contract term based on the Constitution. The court acknowledged the difficulties, the technical problems, of directly testing a private contract clause against the Bill of Rights. Like we discussed, a clause like 5.2.5 isn't a law of general application like a statute is. So using Section 36, the limitation clause, directly is problematic. It doesn't quite fit.
Okay, so if direct application is tricky, what's the solution? How do you make sure contracts are fair and constitutional without getting bogged down in those technicalities?
The majority landed on this. The proper approach is to determine whether the challenged term is contrary to public policy. And crucially, public policy itself is now seen as deeply rooted in our Constitution and the values which underlie it.
Ah, I see. So Section 34, the right of access to courts, isn't just a direct right you can wield against a contract clause necessarily.
But it informs and shapes what public policy is. So if a contract term unreasonably limits access to court, it goes against public policy, which is shaped by Section 34.
And therefore, the clause is unenforceable.
Exactly. It's a slightly more indirect route, but it allows the court to uphold constitutional values like access to justice while still respecting the general principle of freedom of contract. It navigates around the technical Section 36 problem.
That sounds quite elegant, actually. Like using the Constitution as a lens to view public policy, and then applying that public policy standard to the contract. And the court then set out a specific test, a two-question test.
Yes, drawing from that Maloney case again, but applying it through this public policy lens. Two key questions to determine fairness.
What's the first question?
First, is the clause itself, just looking at it objectively, on its face, unreasonable? Think of an extreme example they used, a clause demanding you sue within 24 hours of something happening. That would clearly be manifestly unreasonable, a total no-brainer.
Okay, so step one. Is it objectively crazy? What's step two?
Step two. If the clause isn't objectively crazy, if it seems reasonable on its face, should it still be enforced given the specific circumstances of the person who failed to comply? And here, the burden shifts. The person trying to get out of the clause, like Barkhuizen has, to show there was a good reason why they couldn't comply.
Like your example earlier, if someone was in a coma after the claim was rejected.
Exactly. If you were physically unable to act or face some major unforeseen obstacle, it would likely be unfair, against public policy, to hold you to that deadline, even if the deadline itself isn't inherently unreasonable.
Okay, that test seems logical. Objective unreasonableness first, then subjective fairness based on circumstances. So the $1,000,000 question, or perhaps the R$181,000 question.
Yeah.
How did Mr. Barkhuizen's case actually fare under this two-part test? This is where the rubber meets the road.
Right. So question one, Was the 90-day period objectively unreasonable on its face? The majority said no.
No, even 90 days.
Their reasoning was that the 90 days only started ticking after the claim was repudiated, which meant Barkhuizen already knew his cause of action, he knew who the defendant was, the insurer, and he knew the amount he was claiming. He basically had all the key information needed to get a summons issued. The court explicitly said 90 days is not a manifestly unreasonable period comparable to the 24-hour period described in their hypothetical.
I can see the logic, especially if you know the claim details. But what about the broader context? The court acknowledged the realities in South Africa: poverty, illiteracy, unequal bargaining power. Many people sign things they don't understand. How did they square that with finding the 90-day clause objectively okay?
That's a really crucial point. The majority explicitly acknowledged those realities can be highly relevant to fairness.
Absolutely.
However, and this is the key part of their finding, they concluded that on the specific facts presented in this case, there was simply no admissible evidence put before them to show that this particular contract wasn't freely concluded. There was no evidence of unequal bargaining power in his specific situation, or that Mr. Barkhuizen himself was unaware of the clause or unable to understand it. In fact, they pointed out he acted quickly when first notifying the insurer about the accident, which suggested he was capable of responding promptly to insurance matters.
Okay, so the lack of specific evidence about his circumstances regarding the signing of the contract was critical for the first part of the test. Since the clause wasn't deemed objectively unreasonable, they moved to the second question. Was enforcing it unfair in Barkhuizen's specific circumstances surrounding the delay?
Exactly, and this is really where Mr. Barkhuizen's case ultimately fell short, according to the majority. Remember, he waited 2 years to sue after the 90-day period expired. But crucially, he did not provide any reason for this long delay. Nothing was put before the court to explain why he waited so long.
No reason at all.
None on the record. Without those facts, the court felt it couldn't possibly say that enforcing the clause would be unfair or unjust to him. For all they knew, the majority reasoned he might have just, neglected to comply, simply forgot or didn't get around to it. And if that was the case, allowing him to escape the agreed-upon clause would then be unfair to the insurer who had relied on that clause in managing their business and risks.
So he lost because he couldn't explain the 2-year delay. But putting myself back in the consumer's shoes, isn't there always an inherent power imbalance when you're faced with a 29-page contract stuffed with fine print from a huge insurance company? Does the law really expect every single person to be that vigilant, that legally savvy all the time?
And that is precisely the point where the dissenting judges, Justices Moseneke and Sachs, brought a very powerful and very different perspective to the table. But for the majority, the conclusion was unavoidable based on the lack of evidence regarding the delay. The special plea based on the 90-day clause was valid. So Mr. Barkhuizen's appeal was dismissed. He ultimately lost his claim for the R$181,000.
A tough outcome for him after such a long legal battle.
Very tough. Though interestingly, despite dismissing his appeal, the court made no order as to costs. Usually, the losing party pays the winner's legal costs.
Why not in this case?
Because, the court said, Mr. Barkhuizen had raised important constitutional issues that benefited not just him and the insurer, but really everyone involved in contractual relationships in South Africa. They explicitly wanted to avoid creating a chilling effect, discouraging future litigants from raising important constitutional questions for fear of facing huge cost orders if they lose.
That's actually a really significant move by the court. It's almost like saying, okay, you lost on the facts here, but we value the fact that you pushed these important legal boundaries for the greater good.
Mm-hmm.
Now, while the majority decided the outcome, you mentioned those powerful dissenting opinions from Justice Moseneke and Justice Sachs. They would have ruled differently.
Yes, they would have found in Barkhuizen's favor, and their arguments are absolutely crucial for understanding the full picture here.
Okay, let's hear about Moseneke's view first.
Justice Moseneke strongly disagreed with the majority's approach of looking so closely at Mr. Barkhuizen's individual circumstances, like his apparent affluent middle-class lifestyle, to decide if the clause itself offended public policy.
Why did he disagree with that? Isn't individual fairness important?
He argued that the test for whether something violates public policy should be primarily an objective one. You look at the contractual term itself. Does it have a tendency to deprive people of their rights? You don't focus on the specific, peculiar situation of the individual parties involved when assessing the clause against public policy initially.
Why is that distinction so important?
For consistency and legal certainty. Napier argued that if public policy chopped and changed based on every single person's individual background or perceived sophistication, it would become a chaotic mess. Businesses wouldn't know which standard clauses were safe to use. In his view, the 90-day clause was, objectively speaking, unreasonably short and manifestly inflexible. Full stop. He highlighted just how difficult it is for anyone, regardless of their background, to suddenly find funds for litigation, appoint attorneys, get the necessary documents drafted, and actually serve a summons all within 90 days of having their claim rejected. And he pointed out the stark imbalance. The insurer faced no similar time limit pressing down on them.
That's a strong point about the practical difficulties. Did he draw comparisons?
Yes, powerfully. He looked at modern trends in legislation. Parliament itself had actually extended prescription periods, the time limits for suing against state organs, to 3 years. And those laws often allow for condemnation.
Condemnation, that means forgiving the delay.
Exactly. Courts can overlook a missed deadline if there's a good reason shown. Mosanik essentially asked, if the state itself allows for longer periods and flexibility, why should private insurers be allowed to impose far harsher, completely inflexible rules through fine print?
A very pointed question. What about Justice Sachs's dissent? You mentioned he looked closely at the actual documents.
He did, and his analysis is just scathing about the reality of modern contracts. He described how the main negotiated terms of Barkhuizen's policy were probably in a fairly short schedule document, easy enough to read. But the 90-day clause, it was buried. Page 5 of a separate, dense, 29-page certificate of insurance. He described it vividly. A document with endless provisions in a font sufficiently small to reduce the costs of the paper used while simultaneously discouraging any reasonable person from plowing through it.
Ouch. That sounds familiar to anyone who's received an insurance policy document.
He called it what it was, a classic standard form contract, or a contract of adhesion. Meaning it's drafted entirely by the supplier, the insurer in this case, and presented on a take-it-or-leave-it basis. There's no real negotiation over these clauses. Consumers, he argued, very rarely read or properly understand this dense, fine print. It's less about mutual agreement and more like an imposition of will by the stronger party. And importantly, he stressed that it's not just the poor or illiterate who get caught out. Even educated, affluent consumers rarely digest these massive documents. They rely on the main schedule and assume the rest is, well, standard boilerplate.
That really resonates. How many times have we all just scrolled past pages and pages of terms and conditions online to click, I agree? Sachs's point highlights that huge gap between the legal fiction of reading and agreeing and the everyday reality for consumers.
Absolutely. So Sachs identified 3 key factors that, for him, combined to make this specific clause, Clause 5.2.5, objectively offensive to public policy. First, it directly impacted a fundamental constitutional right, access to court. That immediately raises the stakes. Second, it related to something of significant public concern. Car insurance isn't some luxury item. For many, it's a necessity for modern life and work. And third, the nature of the clause itself. Unilaterally imposed by the insurer, offered no reciprocal benefit or burden on them, was hidden away in the document, wasn't highlighted or drawn attention to, and crucially, it completely wiped out the claim with zero possibility of condemnation, no matter how good the reason for delay.
So for Sachs, the combination of those factors made it inherently unfair.
Yes. He argued that in our new constitutional democracy, the old idea of sanctity of contract can't just be used as a rigid shield to protect fundamental unfair terms. The common law itself, he urged, needs to evolve to ensure basic fairness and equity in these everyday transactions between ordinary people and large, powerful enterprises.
A call for the law to catch up with the reality of standard form contracts. And did Chief Justice Lenga weigh in?
He did, interestingly. He actually agreed with the outcome reached by the majority that Barkhuizen's appeal should be dismissed on the facts presented, specifically the lack of reason for delay. But, very importantly, he reserved judgment on that deeper debate about direct versus indirect application of the Bill of Rights to private contracts. He acknowledged that in this specific case, either approach probably led to the same result. But he deliberately left the door open for direct constitutional challenges to contract terms in future different circumstances. That's a significant signal for potential future legal developments.
Okay, so we've journeyed through the facts, the different courts, the majority reasoning, the powerful dissents. What are the big takeaways here for us? For the consumer, the person signing the contract, maybe even the law student listening in?
Well, I think the first big takeaway is it clearly highlights this complex, ongoing struggle in law. How do we balance freedom of contract, which is important, with fundamental rights and basic fairness? It's not always easy. And while Mr. Barkhuizen himself unfortunately lost his specific case, mainly because he couldn't provide that reason for his delay, the journey through the courts, especially the SCA and the Constitutional Court, established a huge principle, which is that all contract terms, every single one, are now potentially subject to constitutional scrutiny, viewed through the lens of public policy. No clause is automatically immune just because it's in a private contract. That's a monumental shift from the pre-constitutional era.
So even fine print has to answer to the Constitution now via public policy. That leads to the practical point, I suppose. This case is a really powerful reminder of how important it is to, well, try and read your contracts, especially those clauses about time limits or anything that takes away your rights, even the tiny buried fine print, because as we saw with Mr. Barkhuizen, those clauses aren't just theoretical, they can genuinely block your path to justice.
Definitely a reminder to be vigilant. But it also throws up a bigger, perhaps more challenging question for all of us, doesn't it? Especially now in our increasingly digital world where we're constantly clicking agree on standard form contracts we haven't read, let alone understood. What responsibility do businesses really have to make sure that these crucial rights-limiting clauses, the ones buried on page 29, are genuinely brought to consumers' attention, to ensure they're actually understood and fairly agreed to, even when there isn't, perhaps, an explicit law forcing them to highlight every single tricky clause? Is there a broader ethical or public policy duty emerging?
That is a truly provocative thought to leave everyone with. It pushes beyond the specifics of Barkhuizen v. Napier, beyond just car insurance. It's about how we ensure justice and fairness really permeate every aspect of our lives, even down to the smallest print on a contract we might sign without a second thought. Thank you so much for joining us on this deep dive. We really hope you gained some valuable insights into this fascinating intersection of contract law and fundamental constitutional rights.
Yeah, keep thinking critically about these things. Keep questioning assumptions. And remember, knowledge is truly valuable when it's properly understood, and you can see how it applies in the real world.